My name is Abhas Chandra and you are watching Judgment Saga. In today's video, I will share highlight of judgment of Honorable Supreme Court of India. Chairman, State Bank of India versus M.J. James. In present case, on 9th day of February 1984, a memorandum of charges was issued to M.J. James that while working as the bank manager from February 1978 to September 1982, he had committed grave misconduct by sanctioning advances in violation of head office instructions, causing financial loss to the bank. Mr. James, by the reply dated 30th day of March 1984, denied the charges, stating that there was substantial increase and growth in the business of the bank when he was the manager. The deposits had increased from 20 lakh in 1978 to 1 crore in 1982, and the advances had increased from 1.5 crore in 1978 to 6 crore in 1982. As the bank manager, the James was aware that top management of the bank was contemplating a deep trust in advance in view of the comfortable loanable fund availability. He had been asked by Mr. E.K. Andrew, the former chairman of the bank, to grant advances without hesitation. He had got oral instruction from Mr. E.K. Andrew to allow disbursement or drawing from the most of the large accounts. Further, the then director, Mr. C.B. Joseph, was personally involved as he had introduced the borrowers and most of the advance disbursement or drawings were made on the recommendation or insistence. The respondent had claimed that the bank did not have a foolproof system of delegation of financial and other powers to the branches, as powers were conferred on the select managers. The respondent was given to understand by the then chairman and director that he was vested with the adequate powers and the advances would be ratified by the board in due course. The functioning of the branch and the advances were subjected to periodically inspection by the authorities, including the Reserve Bank of India. The respondent had never been cautioned on the pattern of the business conducted by the branch. Subsequently, there was changes in the top management and abrupt restrictions were introduced, affecting the recovery of dues. Appeals should be filed within a reasonable time. What is the reasonable time is not to be put in a straitjacket formula or judicially codified in the form of days, etc., as it depends upon the facts and circumstances of each case. A right not exercised for a long time is non-existent. Doctrine of delay and laches as well as acquaintances were applied to non-suit the litigants who approached the courts or appellate authorities belatedly without any justifiable explanation for bringing action after unreasonable delay. Respondent filed appeal nearly 4 years and 5 months after his dismissal, which was not listed for hearing for over 9 years. Findings in disciplinary proceedings are clear and remain uncontroverted. Respondent's defense in the form of alibi is to be rejected as unproven. Service Code does not stipulate any time period within which appeal may be preferred to Board of Directors whose decision is to be final, but no time does not mean any time. The assumption is that appeal would be filed at the earliest possible opportunity. Inactive acquiescence on the part of the respondent can be inferred till filing of appeal. This acquiescence being in the nature of estoppel, bars him from claiming violation of the right of fair representation. The relief, as granted, has serious financial repercussions and would also prevent appellants from taking further action. Studied silence of respondent who did not correspond or make any representation for 9 years was with an ulterior motive as he wanted to take benefit of the slip up, though he suffered dismissal. Plea that appeal was not dismissed on the ground of delay and laches. Respondent approached the High Court through a writ petition in which directions were issued for consideration and disposal of the appeal, and appeal was dismissed on merits. These aspects cannot be ignored as the exercise of writ jurisdiction is always discretionary, which has to keep in view the conduct of the parties. The Honorable Supreme Court of India allowed the appeal and impugned judgment is set aside and quashed. The Honorable Supreme Court of India also upheld the order of dismissal, and consequently the writ petition filed by the respondent would be treated as dismissed. Thank you for watching.